make the present song. Lily gal, lily gal, lily gal, lily gal, what make the present song. From about the 14 run into 15, I make the present song. From about the 14 run into 15, I make the present song. Lily gal, lily gal, lily gal, lily gal, what make the present song. Lily gal, lily gal, lily gal, lily gal, what make the present song. I make money now, and I'm not holding hand, and I make the present song. I make what make the present so. This make a present, that make a present, this make a present so. This make a present, that make a present, this make a present so. Lily gal, what make you present so? Lily gal, what make you present so? He make a present, she make a present, you make a present so. He make a present, she make a present, you make a present for. Lily gal, what make you present so? Lily gal, what make you present so?
All right, hey, good morning. Good morning to you guys. We are going to be talking a little bit about immigration, and I know a lot of you have questions. I know a lot of you have questions about a lot of things, and especially more recently. Things have been complicated. Things have been complicated on some immigration issues. Some of you may have filed. Some of you may be planning on filing. Some of you have been waiting. Some of you have been waiting for 5 years. Some of you have been waiting for 10, 15, sometimes even longer than that. And what we do understand is sometimes the frustrations, and we deal with that. And just so you know, we do understand some of the folks' frustrations, especially if you have filed not the other day, but if you filed, as in some cases, folks have filed 15 years, 15 years, you name it, a long time. And sometimes people run out of patience, and sometimes some folks are of the view that immigration matters can be fixed just like that in 48 hours. And so we understand the frustrations, and we do not, when folks come and folks, we can detect their frustrations, mind you. But one of the things that we do say is, and we use the P word often, and that is be patient. If you're not patient, then it's just going to complicate matters in a sense, because impatient people sometimes do not get the best results. Having said that, I know a lot of you guys were glued yesterday. Well, you should be, especially with important matters such as birthright citizenship. And to make it plain, that birthright citizenship simply means that if you come to the U.S. on a visitor's visa, or however you sojourn to the U.S., whether you jumped the fence or you didn't or whatever, we are not here to basically speak on who jumped fence and who didn't jump fence and who crossed the border. We're talking about birthright citizenship and the meaning of birthright citizenship. It simply means that, according to the Constitution, that anyone that is born in the United States of America is entitled to citizenship, irrespective of their parents' status, whether their parents is undocumented. In the past, they used terms such as illegal aliens and so forth. And so in modern times, they have preferred not to use words such as illegal aliens and so forth and so on to describe human beings. And so the politically correct term would be undocumented individuals who are undocumented. So if, for example, pregnant woman, a woman who is pregnant, travels to the United States of America on a visitor's visa, and she gives birth to a boy child, a girl child, it doesn't matter. She gave birth on US soil. And so giving birth simply means the child is a citizen of the United States of America. No ifs, ands, or buts about that. The child is a citizen of the United States of America, regardless of the parent's status, regardless of the mother's status. That child automatically becomes a US citizen because that child was born in the United States of America. Now, if it's a diplomat, if the child's mother or parents are diplomats, then it's different. It is absolutely different. So what has happened now is Trump administration is saying, and mind you, millions of people benefited from this. Millions upon millions of people have benefited from this, including those who want to do away with birthright citizenship. So you guys see the hypocrisy and understand the political hypocrisy in all of this. So now let's go back to what the Constitution says, which is what the Trump administration is challenging the Constitution and what the Constitution says. And they're basically saying that, look, the 14th Amendment was meant for just slaves, those children of slaves and who were slaves who were brought here as slaves, and therefore, on one breath, they want to quote the 14th Amendment that is as it suits their agenda on slavery, and then in another breath, politically speaking, they just don't want to believe that slavery was the most heinous crime against humanity. But it is being mentioned here now that the 14th Amendment was only pertained to slaves and their relatives who were in America at the time, and that is part of the argument in front of the U.S. Supreme Court. Those of you who listened yesterday, and so some of you may be asking, well, they benefit you or what? Well, of course it benefits those of you who fall in the bracket, the category of travel to America and some, give birth in America while you are undocumented. Now, it has serious implications if the U.S. Supreme Court rules in favor of the Trump administration. It simply means that they are going to take a look at all those who have gained their citizenship through what is called, at some point in time, it was called anchor baby. Anchor baby. You come to America and you anchor down and you get a baby. And that is what they are targeting at this point in time. So let's go to the 14th Amendment and what the 14th Amendment says. Just to be clear, all persons born or naturalized in the United States of America. Now, before I continue, folks who are born in the United States of America are born U.S. citizens. It's pretty obvious. The Constitution says it. Naturalized citizens are, for example, you're a green card holder, and after maybe, if you're married to a U.S. citizen, and after maybe 3 years, 2 years, 9 months, you can start the process. But after 3 years, you file for your citizenship. Or if you are filing after 5 years on your own, then you go through the process to become naturalized. So there are two, born and the other is naturalized. So once you have a green card and you're eligible to file for citizenship, then you are, and you get your citizenship, then you become a naturalized citizen of the U.S., a naturalized citizen of the United States of America. Now, birthright citizenship means that the individual was born in the United States of America. And the challenge now is, hey, we don't want these people to be citizens. That's what the Trump administration is saying, is arguing in front of the US Supreme Court. And, I shared it on my page yesterday because I want you guys to listen to the arguments. It's serious arguments on both sides. The Trump prosecutor side and Mr. Sawyer, that is, he argued and he argued, and every point he made, majority, if not all of the judges, justices, the U.S. Supreme Court justices, said no. Hey, we don't agree with that. And one of the key points that they argued on was domicile. Domicile simply means that the intent of the parent of the baby born in the U.S., the intent is the domicile to make the United States of America their home. That's their intention. And so one of the justices argued, I think it was the Chief Justice or maybe Justice Jackson argued that, how, or Gingrich, I think, how are you going to prove all of these children when they're born in a hospital? Are you going to bring their mothers so that the mothers can prove their status? All sorts of things happened yesterday. And that is why I'm saying it was a good case for a good argument for you to listen, sit and listen and understand what is happening and the implications. Now let's get back to the birthright citizenship argument, the case that started on April 1st. That was yesterday. It was no April Fool's Day. It was actually the beginning of the hearing of this case. That is very important. I heard Justice Clarence Thomas asked one question, and so that was it. Justice Clarence Thomas is probably the most conservative justices on the bench. And so I would be surprised once this case is finalized, and the decision on this case should be sometime the ending of June of this year. So we're already in April, May, June. In another 2 months, that decision is going to be out. I'll be surprised if Justice Clarence Thomas, who is said to be the most conservative justices on the Supreme Court. And so I'd be surprised if he rules against the Trump administration. But so far, based on what we heard coming out of the justices, whether it's the Chief Justice, whether it's the other justices, those who are in favor of ensuring that the 14th Amendment remains intact and that all those who are born in the United States of America, of course, saving except if they are ambassadors. Say, for example, the ambassador to Guyana, we know Sam Hines, he probably can't make big now, but you never know. Who am I to say who could make and who can't make, right? But let us say, for example, that Sam Hines suddenly he got a child in the United States of America, he and his wife. That child is not entitled to U.S. citizenship. I repeat, that child is not entitled to U.S. citizenship because of the status of Sam Hines. So I'm just using that as an example. I'm using Sam Hines as an example. So his child is not entitled because he's an ambassador. But anybody else, if you jump the fence, like I said, or you come on a visitor's visa or whatever the case may be, then your child born in the U.S. is entitled to U.S. citizenship. And I'm not the one who's saying it. The Constitution is saying this. And so all persons, well, with exception of ambassadors, and if you're at war and you're a soldier at war with the U.S. and you have a child at the time born in the U.S., there are just a few exceptions to that. And so the 14th Amendment, again, and I'm just trying to break it down layman's term so that all of you can get a better understanding. I'm not saying that y'all didn't understand, but we're just having this discussion here. I don't want anybody to feel that I'm insulting their intelligence, but I'm just saying, that we have this discussion here because a lot of Guyanese, thousands of Guyanese will be affected if the US Supreme Court rules in favor of the Trump administration. And so, getting back to the 14th Amendment of the Constitution, which says here, all persons born or naturalized in the United States and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. So, for example, those who are in New York, your child born, your child is subject to the jurisdiction of the United States of America. And your child also is subject to the state of New York. And so the United States has all responsibility. And you also, as a citizen of the United States of America, you owe allegiance to the US. And so that has been part of the argument and so forth, that this is what's happening here, guys. And so what the Trump administration wants to do, is to take away that right. Sorry about that. So what the Trump administration wants to do is to take away that right. And thus far, the argument in the Supreme Court appears to be very, very good in favor of keeping birthright citizenship. I love the argument. I love the questions that were asked by the justices. And so just if I can just talk a little bit about my optimism that birthright citizenship will continue. I suspect that the justices may want to make maybe a slight change to that. I don't know what that slight change may be. Maybe they can add that, and that might be the case, if the father or the mother of the child is a U.S. citizen, then I don't think it will have an impact. Or if the child father or the mother of that child happens to be either a U.S. citizen or a green card, the holder of a green card or what is called a permanent resident card, then I'm not certain that that is going to have any sort of impact on the child. However, if both parents, for example, if the father lives in Guyana or Jamaica and has never come to the U.S., doesn't have permanent residency in the U.S., but the mother comes on vacation and gives birth, and the mother is just a holder of a B1, B2 visa, or whichever non-immigrant visa, well, then that is where the question pops in. So that's where we are with that. And again, if you're now joining us, we're just here to spend a few minutes. I'm not going to be on all day with you guys. I notice we have some folks who are Margaret Nelson saying that applies to his children as well. That's Trump she's referring to. Morning, Mr. Gregory Scott and Princess Queen and Charlene Moses and Margaret Nelson. Let's see what Margaret Nelson is saying Marco Rubio and his children are in that category. Well, Marco Rubio was born over here. Not sure the status of his parents then, but his children, he was born here and his children were born here. So I'm not sure that that would have an impact on his children. Sandra Steele is saying here, those who visit and make a child without residency are not a citizen. I'm not sure what Sandra Steele is saying. That is not what the Constitution is saying. And now let's go back to the 14th Amendment. That's not what the 14th Amendment is saying, Sandra Steele. The 14th Amendment is saying all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state, and this is important, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, property, and so forth and so on without due process. And that's the importance of the 14th Amendment. And so, hope that if any of you have any question as it pertains to birthright citizenship, I think the Constitution is pretty clear on that issue. One of the other things that came up was the subject of American Indians, because they were living in their section that they were basically not recognized as American citizens. And I think that that was one of the questions I think the Chief Justice, John, actually asked the Mr. Sawyer, that's the Trump administration's lawyer, whether American Indians would be considered for birthright citizenship. And he said yes. And then there were some other key questions where I think Mr. Sawyer got trapped, but it was interesting to listen. And again, that is why I actually gave you guys that opportunity to listen. I shared it on my page. I don't want to say I gave you guys that up. I thought that maybe it was so interesting for you guys to listen because it's important for all, especially those who travel to the US and they give birth, travel on a visitor's visa and they give birth, or maybe they came some other way. And then that child who was a born US citizen, that child, when he or she attained the age of 21, filed for you. And that child can file for you because, as you know, if you have a child in the US and is a US citizen, whether they are a naturalized US citizen or a born US citizen, they can file for you, right? Whether you are in the US or whether you are outside of the US, they can file for you. And so we do have a lot of those cases. Those cases are easy cases, simple cases, easy cases, very simple cases. With those cases, what needs to be proven? What needs to be proven is just a relationship to the child. And in those cases, you just need to prove that you are the mother or the father of the child. And the birth certificate and maybe, if needed, other documents. If needed, other documents. We'll take a quick break and we'll be right back.
Money, I know what you're conniving. Money, money, neighbor, money, neighbor, money, money, neighbor, money, money. You can keep your conniving money when you've been not for a bum. In a biz, there'll be money. Now because your money done, you come with conniving money. When you had your pocket full, in a biz, there'll be money. Now because your money done, you hustle for tell me money. Yes, money, neighbor. Money, neighbor, money. Money, neighbor, money. Money, now know what you conniving money. Neighbor, neighbor, joker. Neighbor, neighbor, joker. Neighbor, neighbor, joker. That's all the money that me walk. A 2 pound note and a guilder piece. A 2 pound note and a guilder piece. A 2 pound note and a guilder piece. This is all the money that me walk. I said money, neighbor, money, neighbor, money, money, neighbor, money, money. I don't want you conniving money. Oh, Joseph, for me. Oh, Joseph, for me. Oh, Joseph, for me. Get up this 1 bunch green plantain, 1 string quackwari, 1 jill black pepper. All you can buy with a gilda piece. Yes, money, neighbor, money, neighbor, money, money, neighbor, money, money,
All right, welcome back. A few folks, a few folks were trying to get our attention. And so, yep. And so we just wanted to respond to some of our folks. But those of you who are watching, I can only respond to you once I'm off the air. I cannot respond when I'm on the air. It's pretty obvious. But good morning again to all of you. And if you have any question, one of the things, we've had quite a few at Benchop Immigration Consultancy. We've had quite a few asylum cases. And what I can do is to share about one of the asylum cases that we've had recently. And that asylum case was filed early this year, to be precise, late January, with all of the evidence, because when we do applications, we want to ensure, and not just asylum applications, any applications, come with proper evidence. We will ask for evidence. We will review everything thoroughly before anything is submitted. And that is why we say to people, don't come to us and expect us to rush anything in. That is why we say to people, be patient. Be patient. And we understand why we say be patient, because people sometimes panic. They want things done right away, and it doesn't happen like that. And with these things, if one box is left out, it can cause problems for the application. And so when we do your applications, we take our time with it. All we ask is to exercise patience. We understand how people may feel. They may be panicking because of what's happening out there. We realize that and we respect that. We appreciate that you are concerned. And we are also equally concerned because we want a success story for you. And we can only get a success story is if you allow us to do our job. Sometimes some folks have cases pending for 15 years, 10, 15 years, and they expect it to be done within 24 hours or 48 hours. It doesn't work like that. Patients sometimes get the best of results. And so let me head back into this asylum. And before that, let me just say, we give people good results, the best results, right here and Benchop Immigration Services. Now, this particular asylum case was of interest. The individual came, and we are not in the business of filing frivolous applications. It's not going to happen. We just don't do that. And when we file an application or when we do anyone or any sort of immigration benefits for folks, whether it's VAWA, whatever it is, we ensure that we ask for sufficient evidence, genuine evidence. That's what we look for. And these forms are not like what it used to be before, whether it's VAWA or whatever. Sometimes these forms are 28 pages. We did an application the other day, not for VAWA, but another application for work through a company. And that was like 39 pages. Sometimes you guys think that this is just a 2-page, you just write something and you send it in. No, you have to review and review and review. That is what we do here. We review every application 2, 3, 4, 5 times sometimes. Because if one little box is left out, they will more likely, in most cases, reject the application. Even if you are short of $1 or $5, they will reject the application. Even if you overpay, they may reject the application as well. So a lot of times these things really do take time, and they have to be thoroughly looked at. So that's why we say to individuals, be patient. Now, we have heard of recent a lot of these VAWA applications. Now, I'm just here to talk about what we do and following the law in what we do. And we just don't talk for the sake of talking or fill an application out because we want to fill an application out. As you guys will know, and just in the interest of transparency, as I repeat, at least for now, I am not yet a practicing attorney, but I do have an advanced certificate in immigration law. In other words, I studied, I went to school, and I have an advanced certificate in immigration law. And so I'm just not filling the applications out because one day I got up and I decided that I want to fill the application out. No, it's that I went to school and I studied this and I do have an advanced certificate. Maybe one day soon I'll cross the finishing line and start practicing law. But I do a lot of applications, whether it is VAWA applications. And I'm not going to boast about our success rate, but it's top of the line. And that's all I would say. And so with VAWA application, we've had a lot of questions concerning who can file for VAWA and so forth. And so once a VAWA application, which is Violence Against Women Act, once a VAWA application is filed, it has to be legitimate. Because if it is not legit, and if the evidence is not there, at some point in time, USCIS will reject the application. And that is why you've got to be very careful with how these applications are filed. And who is filling the application out for you should be transparent, should tell you, should be open and to tell you what they are putting in the application, on what grounds they are filing these applications. Because you don't want somebody to fill the application out for you and you don't know what is in the application. And the other thing is, you don't even get to see the applications after they are filed. You don't get control of your case. And if you do not get control of your case, then you are more likely to get yourself in some problems. Because you don't know, you wouldn't know when USCIS is asking or has sent a letter for a request for further evidence, which is an RFE. And if you are left out in the cold about your case, then understand it's a red flag. And so what we do, we give all of our clients control of their cases. And we also not only just leave them on their own after we file the applications, we babysit, so to speak. We monitor every single day, every single case. As maybe some of you are watching, some of you may not comment. As you know, we will comment. We will send a text. We will say, hey, this is an update. This is what's going on. And if folks are running out of patience, I say, of course, it's not something that we can squeeze the hands of. It's not like we can squeeze the hands of USCIS. But what we do is we stay on top of it. We get you in touch with an officer. Of course, for cases to be information to be given out to clients, they have to be the petitioner. They have to be the petitioner or the applicant. And that's the only time the officers, unless there's a G28, a lawyer or whatever, or a representative. And in most cases, what we do is we connect applicants and petitioners who have questions about their cases. We connect them directly to USCIS to speak with an agent, and so that an agent can give them all of the necessary information. I just got a text message from a client, and I am going to say that between yesterday, April 1st, and today, April 2nd, quite a lot of good news as it pertains to some of our clients. This person applied for their N600, which is for their naturalization certificate. And they were waiting in line, so to speak, for the oath of ceremony, and they just messaged me to say the April 2nd oath of ceremony notice was mailed. So if that person, obviously that person may be watching, I just um, wish to say congratulations to that individual. So the N600 application is when you derived or derived citizenship, your um, it's called derived or derived beneficiary. In this case, this person got their citizenship from their parents or one of their parents. And so once you send in that application, the N600 application, with all of the evidence, the requirements, and so forth, then USCIS will review, and they will, of course, make that final determination on whether to approve the application or not. And so that N600 application was approved, and the person now has a date to go and be sworn in to become a naturalized citizen of the United States of America. So congratulations and good luck to that individual. So there's just yet another example where we give you all access, those of our clients, all access to your case. You get to see everything ball by ball, what is happening with your case. Sometimes some people run out of patience, and rightly so, especially in these times, because you want to know what is happening with your case. And there are several things. If folks who are still waiting for an interview, whether it's for a green card interview, whether it is for a citizenship interview, whatever interview, if you think it's taking long, don't think for a moment it's your fault, and don't panic. I oftentimes say to my clients, do not panic. Be patient. That is all. Be patient. And sometimes, most of our clients are very patient. Most of our clients are very patient because these applications are serious applications. These are serious times, and we take people's applications very seriously. And we respect everyone, even the few who are not patient. We say, be patient. You give us a job, let us do it. Let us complete it. It goes into the hands of USCIS. USCIS will make their decision. And 99.9% of the decisions are favorable. 99.9. Nothing is perfect, but 99.9 is favorable. If it is not favorable, we fix it. We find ways, legal ways to fix it. Because with immigration, there's always a loophole, and we usually look for that loophole to fix it. So that is why some folks call me the mechanic, because I fix it. Now, let us touch on another case, which is a permanent residency, a green card application. And for those of you who just joined us, good morning. It's just, I'm not dealing with politics, as you guys know. We're just talking about immigration matters because people have been messaging me, some clients, and people do have questions, people do have concerns. And we're just trying to make this as very simplistic as possible. So getting back into what may cause a delay in a case. Several reasons. One could possibly be that not sufficient evidence were sent in. And that is why we ask all of our clients, we need sufficient evidence. If it's a marriage-based green card application, then we need evidence. Don't just say that, oh, can you fill out the application? I know people, come and they expect the best advice as it pertains to immigration law. And it is our duty to say to clients, you need to make your case strong. You need to give us some more evidence. If it's a marriage-based application, don't just expect the I-130 to be filled out just like that, or the 485. Don't send it in. It's like bare bread. It's like eating bare bread with nothing on it. The officers, USCIS, they want to see something. They want stuff with meat. They want to see something that they can work with. And that is what we ask people for. Give us more evidence. Put the case aside until we are satisfied that there is sufficient evidence to submit the application. Because we are not going to do someone's application if there is not sufficient evidence. One, it will be wasting money, it will be wasting your time, and it will be taking you up an alleyway where it's going to be a 50-50 chance of survival, of approval. Now, we don't want our clients to have a 50-50 chance. I am not comfortable with clients getting a 50-50 chance. I want all of our clients to get a 99.9% chance of getting through. And so that is why it's important that your applications are done properly and not rush. Now, the second thing is that could cause a delay in your application. It could be the officer. It could be the officer is on vacation. It could be the officer quit, because a lot of officers are quitting based on what we read in the news. It could be the officer transferred. And it could be that your case is still sitting. It could be that your case is still sitting in the queue. And somebody forgot about it. That is why it's important, if there is a particular time frame that your case, whether it's 4 or 5 months and you haven't heard anything and you're becoming impatient, and I can understand that. And what we do with our clients is that we ensure that we connect them to USCIS so that USCIS can hear firsthand, not just hear from me, hear directly from USCIS agents or the officers that this is what is happening with the case. Now, they are not going to come outright and tell you, oh my gosh, the officer quit, or, we forgot about your case. They're not going to say that. Of course, they're trained. They're professionals. And neither are they going to advise you with what course of action you should take, from a legal standpoint. They're not going to do that. They're not lawyers to advise on cases. They're not going to do that. But what they are going to say, and they oftentimes do say it, is that it's within the time frame. And that's usually their explanation. They're not going to say anything else, even though it might be something else. Officer quit, the case was transferred to somebody else, or they forgot about the case. They're going to just say, oh, it's still within that time frame. We hear that often. It's still within that time frame. But once you showed interest in your case and you call, and I'm not saying that you got to call them every minute, every week, every other day. Some of you guys don't have the patience, right? Some of you, not all of you. Every day, every minute. Sometimes it's like, be patient and you will see the results. Be patient, and because we like when people get good news, and we like to deliver good news to people. We do deliver good news to people all the time, as in this asylum case I was talking about. Let me just briefly give you a take. Maybe we have some asylum seekers who are watching, and I can understand not everybody's going to want to comment, but we see the regulars just here, whether it's politics, whether it's immigration, they're just about, right? Like Sean Anthony Ben, he's just saying looking sharp because he see me with a green shirt. You don't know where he's heading, political, right? Lachman Aziz, good morning. Mary Figueroa, all the regulars are with us. Diamond Barbs, Paula Jeffers, Margaret and Deborah, all the regulars, Savitri Rose, all the regulars, but the actual people who may have a regular, a question per se. All right, so let me give you guys an experience with an asylum case. An asylum case was filed, at least, as I've said, we want to make sure that these cases are legitimate cases with legitimate evidence. And so the client came and uh, didn't file the application, the asylum application, within the time frame that they should have filed it. And it was just not so long after the quote unquote deadline. Because if an asylum application is going to be filed, it has to be filed within the year that you or that person is in the US. And so this particular client didn't file it. But the law also allows for late filing. However, with the late filing, there has to be an explanation. Why are you filing this case late? And so late January, we were able to offer an explanation as to why, presented all of the evidence in this case, all of the evidence. And lo and behold, I tell you guys this, it's the fastest asylum case that we have done, the fastest. Person within a month and a half was able to get an interview. And all I would say is that success story, successful with those individuals. Successful because all of the evidence was presented. All of the evidence presented. And once you have strong evidence, or even if you come and you don't know what sort of evidence, it is our job. And we are able to talk to people, give us the evidence. If we feel that the evidence is weak, we will put your case on the side. Not that we're ignoring your case, but we want more meat. And so this person had strong evidence and was able to get an interview within a month and a half, in less than 2 months. And like I have said, success story. Success story. Success story. That's all I would say. That's all. And it's the fastest ever. Now let me talk about, and because I know they have a lot of folks with their green card stuff as well. And I want to talk about that, but I'll take a quick minute break so I can respond to some people via text and so forth who have some questions as well. We'll be right back.
Never joke, never joke. Oh, money, never money, never money, money. And I know what you're conniving. Money, never money. You can keep your conniving money. When you've been knocked for a bum, in a bill tell me money. Now because your money done, you come with conniving money. When you had your pocket full, in a bill tell me money. Now because your money done, you hustle for tell me money. Yes, money, never money, never money, money, never money, money. Now I don't want you conniving money. Neighbor, joker. Neighbor, joker. Neighbor, joker. That's all the money that me walk. A 2 pound note and a guilda piece. A 2 pound note and a guilda piece. A 2 pound note and a guilda piece. This is all the money that me walk. I said money, never money. Money, never money. Money, I don't want you conniving money. Oh, Joseph, for me.
All right, welcome back again for those of you who have just joined us. Let's get back into, we spoke about the asylum. We spoke about VAWA, but I'm not yet done with VAWA. I have something else to tell you guys about VAWA because quite a few folks, and let me just say welcome to all of you who are now joining us, Odd, the entire crew, Tenement Yard crew, Odd crew, everybody. Good morning to all of you. Janice Johnson, good morning. And so I will get back to this VAWA stuff because people, they got quite a few people who are not aware that they may, they probably may have been put in removal as a result of someone filing a frivolous VAWA for them, frivolous VAWA on their behalf. And that is why it's important when folks file your application, you have to know what they put in your applications, especially a VAWA application. And if there isn't sufficient evidence, then USCIS will ask for further evidence. And if you're left out in the cold, you don't know what's going on with your case. You don't, somebody else is handling it and you don't know, you don't get to see the letters, you don't get to control your case, then hey, you may be put, you may have your VAWA denied because nobody's paying interest, nobody's taking care of your case, they don't care, they're not taking care of your case. And so when your case is denied or when a request for further evidence is made, you don't know because somebody who did a fraudulent VAWA application for you don't want you to know the truth. That is why it is important that you have your applications done properly and there is full transparency. Do not allow anybody to do your application, whether it's VAWA, but mainly VAWA, but all applications, they should be full transparency. And that's why we say to people, we are going to review your applications with you before we send it out. We are not going to send out your application just like that, as we say in Guyana, just a dry. We want to review all applications with you. And when you see you have a VAWA application and somebody's doing it and you don't know what they file under, you don't know who they put that abuse you and all these sort of things, you don't know who they put that abandon you, you don't know who they put or whatever, then you're heading down the path of a questionable path, so to speak. That is why you need to know. And so quite a few folks have had their VAWA applications rejected by other individuals who probably do not understand immigration law, and therefore they paid some money, thousands of dollars, and then they get their work permit. And then when they get their work permit, they think that everything is okay. In some instances, they may have gotten their travel document or their temporary social security card, and they feel happy. And I can't blame anybody for feeling happy. But that is not the end of the road. Even if you get your work authorization card, it is not the end of the road, because the main application, which is the VAWA application, if it was done fraudulently or if it was done with very little or no evidence at all, then you're heading down you know where. So quite a few folks have called me to say that they don't know what is happening, but when checks are made, when I say checks, I don't mean checks are made. When you check up on their case, some of these folks have been put in removal and they don't know. Some of them have been ordered removed by an immigration judge and they didn't know. And these cases are really, really sad situation. Sad cases to listen to, that people are being subjected to this level of fraud. Because that's what it is. And the question is, how do they overcome? While it might be difficult, again, I say, in immigration, there is always a loophole, so to speak. It is not the end of the road. And if some of you might be, some of you are listening who might have been subjected to this sort of situation, all is not lost. I repeat, all is not lost. We advise, we give our opinions on what the law says to individual. If you stay away from your removal case, if you know that you have to see the judge, and you start to become nervous and frightened, afraid, of course, it's human. I have been able to give my opinion to quite a few clients. contrary to what maybe their lawyer told them. And I'm not here to knock at any lawyer. I'm not here to knock at anybody. I'm just talking about what the law says. And oftentimes I'll say this to people. In most circumstances, most cases, if you have a removal hearing is just a nice term now for deportation. If you have a deportation hearing, go to that hearing. In some instances, you have your case would be put off for another year, another 6 months, another 2 years, another 3 years. And so you get some time, you have some time to, if you can correct your immigration situation legally, you can do that. So all is not lost. And I usually say to individuals on a daily basis, do not panic. Sometimes I got to act as a counselor for individuals who are, for obvious reasons, nervous. And you know, when you're nervous and you run to somebody else, they're going to tell you $10,000, $15,000. We don't do that. We give you sometimes, most cases, free advice. Do not go. I mean, do not listen to people who tell you do not go to your hearing. In most cases, if you do not go to your hearing, you make things worse for yourself. I got a client who, a lawyer, they were dealing with a lawyer, and the lawyer said to them, don't go. So when the lawyer said, don't go to their removal hearing, that he is buying time for that client, I said, why would the lawyer tell you don't go? You have a good case. The person had a denial through the same lawyer, and they were put in removal. There was a new application filed, and they have a new application in the system. Oftentimes the judges look and say, do they have a pending application? And the pending application offers immediate relief. For example, if your spouse refiles for you and so forth and so on, they will take a look at that. And it will be surprising if the judge ignores that. And so in those situations, I would say people should not hide or run away from not going to court. Go to court. But when a lawyer tells you don't go, unless there's a real reason, unless you're sick, and then the lawyer would have to present that evidence to the court, and or present the evidence if there's an accident, God forbid, or whatever, and you can't make it, fair enough. But don't just sit around and say you're not going. So the client, we advise that individual based on our opinion. We say you should go, and the individual went, and they were surprised. The judge says, look, come back in 4 years, fix your house, get your house in order, return to us in 4 years. Another one, return to us in 2 years, and so forth. 2 other persons are in removal. The judge ordered their removal from the United States of America. They never knew that they were in removal proceedings. They never knew because of a questionable VAWA application that was sent in, and the folks didn't know. Now, I want to make this clear because there might be some folks who are in removal or probably didn't know, and they're very nervous, and maybe rightly so because of how things are going these days. Well, I would say that, and we have a client, 2 clients, 3 of them, sorry, came after the fact. They came and they said, hey, but before we do anybody's application, as long as they are here and they had other applications filed, we run a thorough check on the individuals. And so those clients that came to us, before we move forward, we ran a check on their applications to see what is the status. Lo and behold, those individuals had a court date for removal proceedings against them. They missed that court date. And guess what? The judge ordered that they be deported from the United States of America. They never knew anything. And that is why it's important that you know what is going on with your case, you know what is going on with your application, and you get to see things firsthand. Do not depend on anybody to tell you second or third hand information. Know what is happening with your case. And so the folks began to panic because they never knew that they were in removal. They never knew that the VAWA application was denied. Applications were denied, sorry. They never knew that. They never knew that they had a court hearing because none of the letters were going to them. The letters were going somewhere else. And so we were able to say to the individuals, it's not the end of the world. And since it's not the end of the world, there's several things that can happen. You can appeal that judge's decision, or you can file what is a motion to reopen. But you have to have strong evidence as to why the judge should reconsider that decision. As of now, we are awaiting that final decision from the judge, a request to reopen and to reconsider. To reopen under the circumstances that the evidence that we were able to present to the judge is that the parties didn't know. And we gave all of the evidence and reasons why, and letters and other forms of letters as well to convince the judge that the case should be reopened and the person should be given an opportunity for a fair hearing. And so with immigration, there are lots of things that go on behind the scene, lots of sad things that happen behind the scene. People are frustrated. People are desperate. Some people, I'm not saying everyone, are impatient, and rightly so as well. But what we say to individuals, do not be frustrated. We understand why you are frustrated, but we say, do not be frustrated. Do not be impatient. Just do not do that. Do not be frustrated. Do not be impatient. And you will see the results. You will get the results that you want, that you so desire. Do not put your hands up in the air. Do not give up. And we have done lots of cases where people put their hands in the air. Two women call two clients, well, not just women, but marriage-based petition. They got their first interview. They got the second interview. They weren't sure what's going to happen. They were afraid and all manner of things. And we say, let your heart not be troubled. Go in with proper evidence. If you advise, and what we do, we give you a list of what you have to take and cover your grounds, cover your areas, and all will be well. And so we have had several success stories with individuals last week, the week before, and they were able to go in and they got their green card approval. Two of them received their green cards last week. One of them got a positive end result on their asylum application. One of them, who had their work authorization card pending for quite some time, has finally gotten their work authorization card in their hands. And so lots and lots of success stories. We want that to continue. We spend time with you. Sometimes some of you call me at midnight. And for those of you who call me at midnight, I sometimes, maybe fast asleep, but I understand the importance of your calls. But I just ask that be a little reasonable, guys. I know, be a little reasonable. Sometimes the question could wait until tomorrow morning, right? But I always try to respect folks and answer their calls or respond to their messages. And sometimes when I miss one or two, give me a reminder. It doesn't hurt. And let me say good morning to those who are now joining us again, Odd and the whole Tenement Yard crew, and Natasha and Margaret Andrews and Brenda Biley and the whole crew, Miss Greenwich Giles and Gills there. So recently, we did a couple of applications, which are concurrent applications, it's called. You file the I-130 and the I-485, which is the green card applications. And these applications were filed late January again. And yesterday seemed to be yet another good day. I wouldn't want to say lucky day, but a good day. Notice came that in a short space of time, within less than 2 months, again, less than a month and a half, um, interview schedule, interview schedule for green card application, marriage-based green card petition. Now, if you have a marriage-based green card petition that is there and you have to go in for an interview, do not just take things for granted and just feel that you could just walk in just like that. We say, get more evidence, take some more pictures, take in some more pictures. If you have things in your names together as husband and wife, take those things in as well. Know a lot about each other. If you have children, your wife, stepchildren, your wife should know your children's names. Your husband should know your children's names as well. Whether your kid's name's Squash, Belanje, Okro, whatever, you have to know your stepchildren's names. Sometimes they even ask for date of birth. Sometimes they ask, what's the color of your bedroom? What y'all had this morning for breakfast or lunch, if it's an afternoon interview. So they ask these questions not because they want to get personal, but they want to ensure that it is a bona fide, I repeat, a bona fide marriage. That's what they're looking for. They're not looking to get personal with you. Bona fide. I had one client, I think I told you guys, they walked in and the only question I asked is, why do you want this green card? And the woman said, the reason why they ask, why do you want this green card? It is because they had a preponderance of evidence that were sent in that accompany those applications. And so the officers know, for the most part, they can smell a rat if there is a rat. But what we don't want to do, send in anything that would consider ratish, that they have to smell a rat. We don't want to get involved with that. We send in things that the officers could be able to look at. And the minute you get that interview date, we don't give up and we say, days on you now. We try to guide you and let you know what are some of the things to take in, all of the evidence to take in. We go as far, and this is what some of you who may be watching can attest to. I usually advise my clients who are going in for interviews, do not spray the whole bottle of cologne on you or perfume on you. You know, do not feel that you have to overdress, put a set of coconut oil or perfume and cologne and smell up and thing. Go very simple. Respectful, professional, but very simple. And answer only the questions asked. You know, I got some clients, blah, 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 blah. No. Answer only the questions asked. The minute you start to blah, 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 you're setting yourself up for trap. Because sometimes it's the blah, blah, blah that gets some folks their applications a second look on their applications. Answer, sit there as man and wife. You can't sit there as man and wife and you face long like the Demerara Harbor Bridge and your husband face long like Kanji Bridge. The officers, they are trained to see these things. They read body language. They read subteeth and all these sort of things. Go in there happy. Go in there like real man and wife that you are, right? And so these are things that people want to see. The minute you step out of your house to that interview, just ensure that the interview start right there. The minute you walk through your door, because the minute you walk through that door, you hit in the street, you don't even know it could be the officer right there. That you don't even know that person is the officer because, and then you go in the train, you don't even know that you're sitting next to the officer. You go on the elevator, you don't even know that the officer who's supposed to be interviewing you right there next to you in that elevator. And so you're going to suck your teeth and you're going to this. No. Be nice for one day, please. If y'all having problems or whatever, there's nothing that is a perfect marriage, don't get me wrong. But just know that the interview starts the minute you walk through that door, right? And now the other thing with regards to these applications, people may ask, do they have to go with a lawyer? In most cases, and I say this, in most cases, and I repeat, some lawyers may be watching because, again, I know lawyers are there, it's a business and so forth. But I'm being very straight up, right? Very straightforward. You don't necessarily have to go in with a lawyer. You do not have to, because in most circumstances, lawyers are not there to answer your personal questions. Of course, you'll have to pay them, but in most cases, in fact, 99% of 99% of cases that we do here at Benchop Immigration, we advise, we do not, our clients have not gone in. 99% of the cases have not gone in with a lawyer, and they came out smiling. They came out smiling. Now, I'm not knocking at lawyers who tell their people that, hey, you got to pay them extra for carry them. I'm not knocking at anybody. To each his own, right? But my opinion on these cases is that you don't necessarily need a lawyer to accompany you in most of these cases. And almost all of our clients, almost all, have not gone in with a lawyer, sorry, and they are very successful. Very successful. So congratulations to those who have gotten their green cards recently. Congratulations to those who have gotten their citizenship recently. Congratulations to those who have received interview letters recently. Congratulations to those who have had a successful asylum interview. And the list goes on and on and on. Now, I want to touch, as we look at the time, on those who have I-130s and are expecting to undergo what is called a consular interview, meaning an interview at the embassy in Guyana or wherever. I have some clients in Barbados called me a couple days ago and said, hey, they have an appointment, an interview date set, and they asked whether they should cancel that interview because they have some other stuff work related in Barbados. Right away, I said to the individual, your case, because when they came to me, their case was pending for about maybe 12, 13 years. And we got it reinstated. And so we were able to say to them, look, your case you came a long way, long wait. The people now give you an interview date and you want to postpone that interview date, you want to put it off, you shouldn't do it. If you have an interview date, unless there's a real emergency, do not put your interview date on. Go to your interview. And so I hope that my clients in Barbados would be able to, and I think they will be going to their interview, because you don't know what may happen tomorrow. Sometimes some law change, every day you go to bed, you get back. Like, for example, the Haitians, the judge ruled again, the federal judge ruled that all of the Haitians who have had their TPS, it has to be restored. It has to be restored. Temporary permanent status. It has to be restored. And so thousands of Haitians were panicking. So the point is, every day there's something new. There's something new. So if you got to get something done today as it pertains to immigration, get it done. Get it done. And so while we are on the path of success stories, last week we had, and the week before we had, two families went in and they were pretty successful. Um, Two families went in and they were pretty successful. And we say congratulations to them. This week we had another set of families went in and they were successful, a family-based petition. Get all of the evidence, go in, be patient, and you will see the success story. That's all we say to people. Be patient. We are here with you guys. We work with you guys. We want the best for you guys, and we give you guys the best. All we ask is for you to be patient. Turn to your neighbor and say, be patient, and you'll see that results. Now, let me say to you guys, when you're going in on the day of your interview, once you are going in for that interview, double check, triple check. And this is what we say to our clients. Sometimes they might, I said, no, double check, triple check, go over. One of our clients went in, and we don't talk our clients' names, we don't give names, but we just say this so that you guys can use it as a learning experience. And so the client went in, all excited, interview and so forth and so on, and they forgot a document. One piece of document they forgot, and sometimes that can cause the case to be delayed. Double check the night before you go, the day before you go, double check all of your documents. Put them in a folder and ensure that you guys have all the documents, all the evidence needed. Again, we take our time with you guys. We know sometimes some of you, one or two of you may be frustrated that it's taking a little longer than whatever. We understand that, we respect that, but we just want you to know that the process has to be completed properly. And we don't want to rush into a situation. The other thing is, and when we say we got you, we really do mean that we got you, right? Like some folks had their cases pending for donkey years, as we say in Guyana. Donkey years, as we say in Guyana. And then when they come to us, we were able to revive their case because their case dead, done, blackout, so to speak. And we take that case and we bring it back alive. Right? Because even if you have a case and they say that it's closed or whatever, you could bring that case back alive. And that's what we do with a couple of cases that were pending for 15, 16 years. But not because we were able to successfully bring your case back alive. It's called to have your case reinstated. Because not USCIS, it's approved by USCIS, gone over to NVC and the State Department, sent over to the Guyana Embassy. And if you do not follow up, and a couple of years pass, they'll consider that that's it. If you don't respond within a year, they will shut your case down. And if you made any deposit, you lose your money as well. But what we were able to do is to reinstate, have people's cases reinstated. And some of them who have had their cases, one or two, pending for 15, 16 years. Oh, man. You can't expect us to just bring about miracles in 2 weeks, 3 weeks, a month, or something like that. You will get your victory, as some have gotten their victories. Lots have gotten their victories. But I also understand, because you guys know as a human rights activist as well, I tend to put my hats on, my human rights activist hat. And I see with people, I understand people's situation. That is why I'm here to hold your hands and work with you step by step to get the results that you deserve. We're not here to just send in your application just like that. We're not comfortable, because when you win, we win. We want all parties to win, but our mission is to see you win and to guide you through that process. Like one guy called, and I'm using these examples so that you guys can pick up and learn from it, so to speak. They want me to do their citizenship application for them, that the individual wants to go and join the US military. I think in the army, and they want their naturalization certificate. So the naturalization certificate is a form N600. The N600 is about $1,450 or something like that. So immediately I'm like, this person doesn't understand the process. That's why they're calling. I could have easily said, look, let's do the application, $1,450, I believe. These prices keep going up. And then, of course, our fees. But when the person said, because they want the naturalization certificate so that his son could join the U.S. Army, immediately I'm like, come on, it's not necessary. I said, you have money to waste. I said, your son has a green card. Your son can join the U.S. military like that. And once your son joins it, then guess what? The military will take care of your son's naturalization certificate. You get to save your money. And the person was shocked. I said, that's what we're here for. We don't want you to waste your money. And we're not going to allow people to waste their money. So if that person is watching, let your son join the military and he can get his citizenship for free once you join the military. Good luck to that individual. What else we can touch on immigration-wise before we go? So kudos to those who have gotten their immigrant visas from Guyana. I had a case, 2 clients from Italy. And it was unfortunate. Well, they came afterwards. They had their lawyers and whatever, and then they thought that they can do it on their own. And sometimes it can be a bit tricky if you don't know. It's not just simply filling out a paper. You have to know. You have to understand. Some applications, folks can just, we can just do it on our own. Some people are like that, and fairly okay. So the clients from Italy, they came earlier this year, and they asked a question. They said that the I-485 was taking longer than expected. And I asked who did it. They said, well, they were working with an attorney, but the attorney, people always with something, attorney this, or it's okay, but I didn't want to use up much of my energy on that. I want to deal with the issue at hand. And they didn't, with their application, they did on their own, they didn't send in their medical. And right off the bat, I said, this may be a problem because you didn't send in your medical. The rules have changed that if you are going to file your I-485, then you have to send in the affidavit of support. And in sending in the affidavit of support, you also have to send in your medical. Now, if you don't send it, in the past, you could just send in the 485 without your affidavit of support and so forth, and your medical, and they would send you an RFE later on. But Trump administration has since changed that to say that the 485, you have to have your medical and your affidavit of support. And so the clients from Italy didn't have their affidavit of, didn't have their affidavit of support, didn't have their medical. And so right away, I said to them that is problematic. Whoever advised you guys, that's not the best of advice. And lo and behold, they got a denial of the 485 on the grounds that they didn't submit their medical. So I say all of this to say, do not lean on your own understanding in thinking that the applications are simple and you could just fill it out on your own. In some instances, yes. But if you don't know of recent updates with immigration law, it could cause you some problems. And it did so with those individuals from Italy. It did so, and they paid the price. But it doesn't mean it's the end of the road for them. It doesn't mean. So I just use that as another example. Again, the other thing too, the fees, almost every other day, fees are being changed. And if the wrong amount is sent in, then it happened to me maybe once or twice. Nobody's perfect. But if the wrong fees, that is why you've got to double check. You've got to double check because you don't want to get hit, right? But luckily, there is not a denial, but there's a rejection on the issue of either you overpaid or you underpaid. And so at all times, you've got to double check that it's the exact amount of monies that's going in. If you don't send the exact amount, or you overpaid or you underpaid, you stand a chance of getting your application or applications rejected. So be very, very careful with that as well. And that is what we do here as well. We try 99.9 or 100% in being extra careful to ensure that the fees are correct, to ensure that the form editions are up to date. If they're not, if they're old versions, they will reject. And Trump administration has also said, give the immigration officers the power not only to reject applications, but to deny the application. But good news is when applications are rejected, they give you an opportunity to correct it. And once they give you an opportunity to correct it, do it right. Or if it's with us, we will ensure that it is done right. Like I've said, we are here for you guys. I notice some of our clients are watching, and we wish them all the best, those who have interviews. Finally, if you have an application for a 485 or an I-130, sometimes you've got to be careful that when you put the interview, who you would want to have jurisdiction for an interview, whether it's back in Guyana at the U.S. Embassy there, or in Jamaica, or in Trinidad, or in Italy, or wherever you want the interview to take place, please double check that you put that place where you want the interview to be taken care, to be conducted. If you don't, then NVC is going to assume that your interview will be done in Guyana or Jamaica or wherever. This time you are over here. And then you have to now rush to correct that problem. But let me say now with that, the rules have changed somewhat. You could change jurisdiction back in the days. But as of sometime last year, the Trump administration said, no. We're not giving you an opportunity to change your jurisdiction, and so forth and so on. But like I've said, and I oftentimes say, in immigration law, there's always a little piece that you could peep through that immigration hole and you will be able to find a success story. And that is what we look at in all of our cases, especially the difficult cases. We look for that success story. And I close by saying, all is not lost. A lot of people used to panic that Trump administration is going to do this, he's going to do that. I'll tell you this based on our experience here at Benchop Immigration Services or Consultancy. We have not had a situation where our clients had to panic. Our success rate continues to be the same or even better now. Now, I'm not saying that people should not panic. People have every right. But when you come to us, be calm. You know, we have some clients, they panic, they call, they panic, they call, they panic. But we understand people have a right. People have a right to be concerned about their applications. People have a right to be concerned about their kids. People have a right to be concerned about their wives or their husbands. And we see with people. We don't get angry. We just ask, be patient, and you will get the results, the positive results that you need. That is what we do at Benchop Immigration Consultancy. We get you that result, or those results that you want. Those who have appointments or interviews coming up, we wish you all the best. And for those who have success stories over the past week or 2 weeks, we say congratulations to all of you. If you have a case and you want to make contact with us, feel free to give us a buzz and feel free to put your case in our hands. We take care of you from the beginning to the end. We celebrate with you as well. Thank you all so much. And as we would say, keep hope alive, be patient, be smart, but most of all, be honest with the things you put on your applications. And don't talk, Guyanese like to don't talk your story to everybody. Keep your immigration matters to yourselves or to your close loved ones that you trust. God bless you. And I'll see you guys tonight on another topic that's politics tonight. We close with, again, to repeat my optimism that the Supreme Court of the United States of America will vote in favor to keep birthright citizenship, and to maintain the 14th Amendment. See you later, and thank you all for tuning in to this immigration discussion that we thought would have been just a few minutes, but it's more than just a few minutes. God bless you, and continue to be safe, continue to be smart, and continue to do what is right. So long.
Never Joe, never Joe, never Joe. Oh, money never, money never, money never, money. I know what you conniving. Money never, money. You can keep your conniving money. When you've been knocked for a bum, in a bill tell me money. Now because your money done, you come with conniving money. When you had your pocket full, in a bill tell me money. Now because your money done, you hustle for tell me money. Yes, money never, money never, money never, money. Now don't want you conniving money. Neighbor joker, neighbor joker, neighbor joker. That's all the money that me walk. A 2 pound note and a guild piece. A 2 pound note and a guild piece. A 2 pound note and a guild piece. This all the money that me walk. I said money never, money. I don't want you conniving money. Oh, Joseph, for me. Oh, Joseph, for me. Oh, Joseph, for me. Get a piece, 1 bunch green plantain, 1 string quackwari, 1 Jill black pepper. All you can buy with a Gilda piece. Yes, money never, money. I don't want you conniving money. When you've been knocked for a pound, in a bill tell me money. No, because your money done, you come with conniving money. When you had your pocket full, in a bill tell me money. Now because your money done, you hustle for tell me money. I said money never, money. I don't want you conniving money. Money never, money.